the opening event of the 2014 Law Union Conference. And we've got some fantastic speakers lined up for you today. However, tonight is only the beginning. Tomorrow we've got a full slate of really interesting and provocative panels and workshops. So pick up a program, they're going to be outside, have a look, and I'd like to invite you all to join us here tomorrow starting at 9 a.m. And now, before we get started, I'd like to turn the stage over to Elder Laureen, who's going to open the event for us.
Saskatchewan Gym Club. I've been given tobacco today to do your opening for you, and I've placed two bowls up here on this chair. One contains tobacco and one contains sage. That tobacco, if anybody wants to come and take some of it and hold that for today and let that medicine work for you, and also that sage, which is a women's medicine, I brought as well, so that if anybody wants some of that, they can come and take that from here. I just want to make sure that everybody's mindful today that the teachings that we follow are those of being gentle and kind and respectful to each other. So when we're sitting here today and listening to the speakers speak and the conversations that will take place, to keep in mind that we're doing these things in a good and kind, gentle way, and that we treat each other to that same effect, so that our words will be spoken from our hearts, but done with kindness. Today's society that we live in, there's too much violence. There's too much talk being done towards each other that's not done in a good way. And none of us benefit from that. It doesn't help support us, it helps tear us apart. And so I want to bring that to everyone's attention today, that if we can treat each other in a kind and gentle way with respect, regardless of our idealisms and our beliefs, our cultures, our nations, the territories which we're from, we don't have to agree with everyone. However, we should be respectful and kind to each other, because we each believe that our opinions and our views are correct for what we know, to the best interest and the best ability that we have. So it's not in our way to tell anybody that their ideas and their viewpoints are wrong, because in turn they can turn back to us and say the same thing. So we would accomplish nothing in that way. And unfortunately, that's the way that a lot of us live today, in the city of Toronto, that we're not treating each other kind and gentle. And throughout the rest of Canada, each of us, suffers every day from things that are said to us and actions and other people's thoughts that are tried to be imposed on us. So be mindful of that today as we gather today and throughout the weekend. And I'd like to call upon those ancestors to come and sit with us today, to be here to help us do that work, to carry those teachings of love and respect and humility and bravery. Because, it is a point of being brave when we use our voice. Too many of us are silent for too long on many issues. And those that do speak today will be using that bravery that they found their voices, and they can express the thoughts and the emotions and speak about the subjects that we will hear today. So I want to give thanks to all those that will speak today, and give thanks to those ancestors for when we call them, we know they come and they sit with us, and they help us to whatever means we ask for. I'd also like to thank each and every one of you for coming today, to giving up your time and your space, being away from your family and your responsibilities, making space for this event to happen. You have put your thought into that, so thank you for doing that and coming here to hear what's going to be said this weekend. So hi to the Creator, and hi to all those ancestors, and may we treat each other as the Creator would want us to behave, with love and kindness and gentleness. So be well, each and every one of you, and enjoy the rest of this evening of what's coming for you. I have a wish.
And now it's my pleasure to introduce our moderator for this evening. Audrey Huntley. Audrey is a documentary filmmaker, community researcher, and writer and producer of mixed European and Anishinaabe ancestry. Audrey is co-founder of the coalition group No More Silence, which addresses the injustice and impunity surrounding the murders and disappearances of Indigenous women, girls, trans, and Two-Spirits. And she's been doing community-based research in Indigenous communities in BC and Ontario since 1998. Please join me in welcoming Audrey.
Thanks so much, Kim. So I've become Amish native since I last checked. Yeah, that's card transcription. For people who aren't familiar with that, there's actually someone not here in the room, but hearing us and typing everything that we say. So we're trying to get people to speak slowly and as clearly as possible. And if the transcriber doesn't understand, she will let us know by typing that on the screen. So I'm really grateful to have joined the Law Union. I'm a pretty new member, and I'm joined because I'm becoming a paralegal. And I just want to thank the other members of the committee. Been a lot of work gone into organizing this conference. Today is just the first day, but I would like to thank Sarah Chartel, Howard Morton, Kim Condon, who we already heard from, Jackie Kotek, Colin Lyle, Rosemary, sorry, I can't read my writing, so I don't know how to pronounce your last name, Nana Yanifel, Maria Gorlas, Andrea Demchuk, Kathy Lee, Stephen Sego, and Patricia Riley. Yeah, thanks to Law Union for being so welcoming and allowing a new member to have so much space. I got to organize this panel, and I'm also involved in organizing 2 of the panels tomorrow, so I hope to see you at. Yeah, my role isn't going to be much more, I'm not going to do much more than introduce our wonderful panelists who have agreed to come out today, and afterwards I'll moderate a Q&A. People can, we'll have mics that will go around. So without further ado, I'm going to introduce Terri-Jean Bedford, who I'm really excited to have here today. Terri-Jean is Canada's most famous dominatrix and has worked in all aspects of the sex trade. She has been fighting Canada's prostitution laws for 20 years and was a plaintiff in Bedford versus Canada, which struck down 3 key laws. Please join me in welcoming Terri-Jean.
Thank you. Excuse me. Before I say anything else, I'd like to acknowledge Dr. Henry Morgenthaler, who died this summer. I appreciate what he was up against, not just because I have been in legal wars and in jail too, but also because both of us were advocating for women. Blessed be his memory. Now, on the lighter side, let me tell you a little story I think you'll appreciate. Some years ago, I was whipping a client strapped to a bench. With each lash, he had to call out, "Ow, thank you, mistress, another please." And he had to sound like he meant it. After he had whipped to my satisfaction, I removed his restraints and let him kiss my boots. Then I told him to get dressed and meet me at the front door. Now get this. When I let him out the front door, we said goodbye to each other. He said, "Good night, mistress." I said, "Good night, Your Honor." Speaking of judges, our judges now, thankfully, are addressing the federal government's so-called tough on crime agenda, which is a scam. The government itself is an offender if laws passed are unconstitutional or contrary to Canada's values. Is it patriotic to focus on length of sentences and ignoring overcrowding in prisons? Ignore the misuse of warrants. Ignore the underfunding of legal aid. Ignore spousal abuse. Ignore the shortages of shelters for women, or of shelters that accept family pets, so the wife beaters can't use the family pet as a hostage. Is it patriotic to be caught by surprise by the sexual harassment scandals about women and minorities in the armed forces and the RCMP? And, my friends, is it patriotic to tell women they can only have sex for free? Did you know that our constitutional challenge prevented a mandatory minimum prison sentence for keeping a common body house? Even a sad sack like former Justice Minister Rob Nicholson should have realized that the law was flawed. Justice Himmel struck down the law in 2010, and the government was caught completely off guard. They didn't even know the decision was being released. I doubt if Mr. Harper and Mr. Nicholson even knew of the challenge. Yet an appeal was announced within 3 hours of the release of the decision, despite the fact that Judge Himmel said Parliament's involvement was required. Same reflex reaction after losing at the Ontario Court of Appeal. Nicholson said the government's position was still that the laws were constitutional. Beverly McLaughlin and the Supreme Court, in my opinion, then confirmed that Mr. Harper and Mr. Nicholson and their cronies were either liars who just wanted the issue to go away or dummies. She did not say which. Take your pick. Then remember that this is the same gang that may be drafting new legislation. Mr. Harper has replaced Mr. Nicholson with Mr. McKay, the former defense minister. Women and minorities being harassed in the armed forces is more of a problem than enemy fire. Let that be Mr. McKay's legacy. Now it appears he is going to add to it by bringing in new laws that will not stand and will not be enforced or obeyed. Perhaps something like the so-called Nordic approach. If they bring that in, it will blow up in their face. My fellow speakers will be telling you all about that shortly. But I want to make a couple of observations of my own. Excuse me. For one, that approach targets men, and Mr. Harper gets more support from men than women. The government that brought in that legislation are more left-wing and more female-supported than Mr. Harper's government. It also means that we women can now accuse a guy who took us to dinner of trying to buy sex from us. The potential for blackmail of men is endless because women cannot be charged for selling sex. I'm sure Mr. Harper's power base of white-collar men will be thrilled to have that hanging over them. And remember something else, something very important. The other countries who outlawed the purchase of sex acts, whatever they are, did not have a Himmel decision, which the Supreme Court has made a guideline for new legislation. Those very laws from other countries might be illegal in Canada. Discriminatory, too broad, overreaching, working against their stated objectives, blah, 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 and on against the Nordic approach. I think we get it. Judge Himmel said the laws, other than the ones she struck down, address the worst aspects of prostitution, aspects which, in large measure, resulted from the laws she struck down. So no new laws need to be introduced. The higher courts agreed. They seemed to say that there is nothing less patriotic than to take the position the government has taken and is considering. And of course, law enforcement officials point out that serious criminals would go undetected and unpunished if resources had to be devoted to ensuring women only had sex for free. And there's more. Perhaps most important of all, new legislation must tell us what we cannot do in private as consenting adults, for money or not. So the Supreme Court said new laws, if vague, would not be viable, whatever the approach. When a new law comes in, it will have terms of reference. It will say, for the purpose of this act, a sex act is defined as, and blah, blah. If the blah blah is not clear, the law is not itself legal. Thank you, Beverly McLaughlin. Home run, girl. Now tell me, what part of all this does Mr. Harper not get? Why didn't Mr. Nicholson and Mr. McKay, who are lawyers, resign rather than advocate laws that everybody knows are unworkable and are a disgrace to a free society? I cannot comment responsibly about Mr. Harper's economic, foreign, or environmental policies and so forth, but what I can say is that in my opinion, on matters of criminal justice, he has fallen beneath the dignity of the many criminals he says he's getting tough on. Not only that, some of you may have heard that Mr. Harper keeps calling me and offering to appoint me to the Senate as a government whip. Well, I'm a convicted prostitute, and he keeps trying to buy me. So he would be a John. I'll have to report him. No means no, Stevie. Bad boy. Well, enough about him. I also want to talk tonight about lawyers and my long journey at their side. First, I want to bring to your attention that I believe Val Scott, Amy Leibovich, and I got too much credit for striking down the prostitution laws. Our legal teams got too little credit. Let me drop a few names. Professor Young, Marlis Edwards, who fought for Dr. Morgentaler, Ron Marzell, Stacy Nichols, Sabrina Pingatori, Katrina Pacey, Kendra Reinhardt, Daniel Shepard, and other lawyers fought for our side directly and indirectly. I have been fighting, and my lawyers have been fighting on my behalf against the laws that were struck down for 20 years. In my youth, I was too poor and lacked the support to contemplate challenging the laws. But in 1994, when I was raided in Thornhill, that changed. I had support. You can read all about that in my book. But with that support, I took a position. I was selling role play and refused to sell sex. Yet, I was raided and charged as a prostitute. David O'Connor represented me at my bail hearing and did a good job. The late Ken Danson began my defense preparations, and Morris Manning took over from him. Morris also represented Dr. Morgentaler. My supporters recommended that change, and Ken was supportive. Ken told me even after he was replaced, "Terry, you can't plead guilty. Promise me you won't." Morris lived up to his reputation, and at my trial, he had the charges thrown out because they were too vague. Unfortunately, that did not hold up in appeal. Murray Klippenstein took over. He worked with Charlie Campbell and was advised by Paula Roachman and assisted by Wendy Snellgrove. That was in part because I and my supporters felt that lawyers with a reputation as activists were going to be important as the matter became a high-profile battle of attrition. To the team, and he was ready to take over if the Klippenstein team was disqualified, and he did. He was assisted by lawyer Leah Daniels, who taught at Seneca when my trial got underway in 1998. They spent all summer on the case and had a team of students assisting them. It was a barn burner of a trial. The CNN truck and all the major networks staked out the courthouse in Newmarket, wherever that is. The trial went on for weeks, and the questions to be decided, as some reporters say, were as fundamental as those raised in the recent Supreme Court decision. In my view, more fundamental. Judge Roy Bogowski, with all the mass media assembled, gave a short oral decision. He said, "The people there had to make a living and were in a hurry to leave." What a fool. He was lucky to get a seat at the trial. He refused to say which of the things I did were not legal, and what he did specify was for such poor reasons that no appeal that was not rigged would uphold such a disgusting miscarriage of justice. He said the misuse of the search warrant was an understandable reaction of young bucks. Rosie DiMano finished off his reputation for good in her column. Professor Young and Paul Burstein, who needs no introduction, did the appeal in 1999. Excuse me. Well, Judge Finlayson of the Ontario Court of Appeal wrote the worst decision in its history. Read it sometime. It was, excuse me. It was so poor. Lawyers told me that it was meant that a stripper or a waitress could be charged as a prostitute, and it was almost impossible to have a search warrant that could be challenged. It was so poor that judges afterward threw out prostitution and body health charges simply because my conviction and appeal decision were such garbage that they became precedents to cite when acquitting. Ever wondered why prostitution convictions fell steadily, since despite the rising population and the growth of the sex trade, whatever that is? In part, Finlayson. Some of this was pointed out by now Judge David Corbett, who sought leave to appeal to the Supreme Court. He worked with Lucy McSweeney and Timothy Banks, then an articling student, when David prepared his masterful factum in 2000. Unfortunately, it was not heard. Professor Young remained active for me. When I reopened in downtown Toronto just after my conviction, he asked the police if they had any objection to what I was doing, which was identical to Thornhill, which resulted in a massive raid and trial. I was open 4 years, no raid, no trial. Another lawyer, Pierre Cloutier, advised me on and assisted me in the handling of the administrative matters of my business, like registration, minute books, and so forth. Just after I closed, Professor Young told me he was considering challenging the constitutionality of some of the prostitution laws in court and wanted me to be one of the plaintiffs. Want to know what's involved in a charter challenge? Try it sometime. $500,000 for starters. Add to that tons of volunteer legal time, the work involved with experts. Try 3 years of hearings and related preparation. Try dealing with government lawyers who do not hesitate to offer crap as evidence and argument. If you don't believe it was crap, ask Judge Himmel in the Supreme Court. Try to deal with a government that orders the lawyers to make it go away by any means necessary, and then orders them to appeal when there are no grounds to appeal, simply to make the issue go away. A government that has no regard for charter challenges. Then try dealing with a portion of the media who in one breath points to the downside of the sex trade, whatever that is, while turning a blind eye to the finding of the courts that the very laws they are fighting to retain are largely the cause of those evils. Try dealing with commentators who bring in obscure new studies or reports not tested in court to attack legalization of the sex trade while ignoring the findings of a virtual 3-year public inquiry, with evidence tested in court that resulted in the Himmel decision and what it had to say about other countries. Barbara Kay and Margaret Wente are 2 recent examples of such cherry pickers who didn't even say in their columns if they'd read the decision. Rosie DiMano said, "Read the damn decision," out of frustration with such lousy journalism. It was never our intent to work our way to the Supreme Court. If Mr. Harper and his justice ministers were doing their job, they would have said that even if Judge Himmel was partly right, the laws needed changing and not defending. They had the choice of acting all along, but they put themselves first. In 2011, I published my memoirs where I tell about my legal battles. I got help from, you guessed it, a lawyer. Senator Hirshhorn and his staff were wonderful in ensuring I was within the law in writing the book, in what I said in the book, and advising me on drafts. He wrote to those mentioned in the drafts and sent them copies and made sure that no one had grounds to sue me. He also helped me with the writing and was encouraging throughout. He assisted me in my private legal matters as well. So you see, there is a great deal that lawyers can do for their clients in the sex trade, or those considering entering it, other than just react to charges or arrests. Lawyers can act proactively. Chandelle and Karin are going to talk about that, and believe me, they know their stuff. And I'm grateful to share this time with them tonight, because what they have to tell you is very important. I want to conclude by sharing just one last thing with you about lawyers, and it's the same lousy joke I tell whenever I speak to an audience of legal professionals or law students. The one good thing about the joke is that it's so bad, it ensures I have to shut up and sit down immediately. Here's the joke. What's the difference between a dominatrix and a woman lawyer? Answer, the dom returns phone calls. Thank you all very much.
Thank you so much, Terry. Just occurred to me that I wanted to acknowledge that we're on Indigenous land. Should have done it at the beginning, but I'm doing it now. This is territory that's been shared for thousands of years by Haudenosaunee and Anishinaabe people. Also some Huron-Wendat along the way. Our next speaker is Terri-Jean. She was called to the bar in 2005 and founded a feminist-identified legal practice in Ottawa in 2006, offering services to low-income women, survivors of sexual violence, and queers in the areas of human rights, administrative law, and civil litigation. With her colleague Leslie Robertson, she is counsel to prostitutes of Ottawa, Gatineau, Work, Educate, and Resist Power. And she provides advice to them on police violence towards and the human rights of the Ottawa sex work community. She also acted as co-counsel in various intervenor applications in Bedford and SWAV on behalf of Power, Stella and Maggie's. Karine is currently on sabbatical from her practice and giving hard thought to whether a solicitor-client relationship within the currently constituted legal system can truly embody feminist ethics. Please join me in welcoming Karine.
My name is Karin. I want to thank Law Union for inviting me. It is truly a pleasure to be able to share a panel with Terri-Jean and Chandelle and Audrey. So I am here to offer some thoughts about what Bedford changed, what is on the horizon in terms of legal regimes, and what type of social and political context these reforms are occurring in. But before I do that, I'd like to start with a story about my first entry into advocacy, which came in the summer of my first year of law school, which, as you can imagine, is a very exciting opportunity for first-year law students. I was working at a union-side labor firm, and they had provided me with a small claims pretrial on behalf of a woman who was being sued by a man who she had met at work. And in the context of meeting that man at work, he had given her his debit card and said, you know, if you need to take money out from time to time, I understand your personal circumstances may be challenging, go ahead, here's my PIN number, go ahead and take that money out when you need to. Somewhere along the line, this individual decided to sue her. And I was told by the law firm, this is a no-brainer. He gave her his card, he gave her his PIN number, and you're fine. So we go to the pretrial together, and the judge is really drilling at this guy. Why is this a claim? Why are you even suing her? You gave her your card. You gave her, your PIN number. It sounds like you understood this was all going to happen. And the guy says, but you need to ask her where she works. And the judge turned to my client and said, where do you work? And then said, she's a stripper. And immediately turned, and the focus was on her being a stripper. Immediately there was distrust towards her. And the remainder of that pretrial was about questioning her and what she could have done wrong. So it was a really great lesson for me in terms of advocacy. It certainly was very challenging, but it also left me with an underlying theme that I think you discover as you move towards your law career, which is the extent to which stigma and violence is embedded within our legal system and directed towards marginalized communities. And then, of course, the question is, to what extent are we complicit in that system when we're lawyers that take part in it. So, you received a few introductory remarks about why I'm here. I have acted as co-counsel for Maggie's, Stella, and Power before the Ontario Court of Appeal, and with intervener applications to the Supreme Court of Canada with Leslie Robertson and the amazing Cynthia Peterson, who you'll hear from tomorrow, and Charlene Wiseman of Sackville Blatt Mitchell. Also do a lot of support with Power in Ottawa to mobilize against ongoing and very targeted police violence towards sex workers. And I have also worked with individual sex workers as clients in my day-to-day practice. I work with sex workers because, first of all, they are my friends. Secondly, because I believe sex work is work. Thirdly, because I believe that our society's inability to acknowledge sex work as work is indicative of the way in which we view women's sexual autonomy as deviant, threatening, and harmful. And finally, I do this work because sex workers are being very much harmed by laws and stigmatization and or dying. So let me offer a few comments about what Bedford has changed. Being a lawyer, I'm a bit of a pedant about sort of how things happen. So I'm just going to unpack the decision a little bit for those of you that aren't familiar with it. So first of all, a unanimous decision from the Supreme Court. So a really resounding message from the Supreme Court that the current regime is entirely inappropriate. And the starting point for the Supreme Court was that it is not a crime to sell sex for money. And with that as the starting premise, it was very difficult to find that there had not been a charter breach. The criminal code prohibitions, the Supreme Court said, do not merely impose conditions on how sex workers operate, they impose dangerous conditions on a legal transaction. So the three provisions at issue were examined for their impact on Section 7 rights, specifically the rights of an individual's security of the person. Section 210 was the first provision that was challenged, which prohibited the operation of common bawdy houses, defined as any place under the law that is used regularly for the purpose of prostitution. This provision, as you likely know, prevents sex workers from working out of fixed indoor locations such as brothels or their own home. The Supreme Court said that the impact of these laws was grossly disproportionate because it prevented fixed indoor locations for sex workers, interfered with their ability to undertake preventative health practices, and prevented a resort by sex workers to safe houses. For example, a location called Grandma's House that had been established in Vancouver around the time that there were, a growing understanding of women disappearing. And in so doing, the Supreme Court commented that Parliament has the power to regulate against nuisances, as they had claimed their legislative objective to be, but not at the cost of the health, safety, and lives of sex workers. A law that prevents sex workers from resorting to a safe haven, such as Grandma's House, is a law that has lost sight of its purpose. Section 212 was the second provision at issue. This section prohibited living on the avails of prostitution, preventing anyone, including to, but not limited to pimps, from profiting from another's sex work. It applied to a variety of relationships in which someone else is viewed as having a vested financial interest in someone else's work. Anyone who is hired by a sex worker to assist them with their work runs the risk of being captured by this provision. The Supreme Court said that this provision was overbroad because it prevented security-enhancing safeguards. So Power, Maggie's, and Stella, in their intervener application, which was unsuccessful before the Supreme Court hearing, had really wanted to attack this particular provision because it had been upheld, it had been read down by the Ontario Court of Appeal, said there's some merit to it, let's keep some of it on the books. And they really wanted to emphasize to the Supreme Court that the effect of this provision was really to say that sex workers can't be trusted to choose their own relationships, which is at odds with the other legal constructions of sex workers as your sort of, your evil, woman who's going to draw all sorts of criminal activity towards her in the neighborhood and sort of eat your children. But when it came to this provision, it's a very, very patronizing embodiment of a sex worker who really, doesn't know and is vulnerable to any type of manipulation. And certainly this kind of prohibition on third-party relationships is not one that's placed on workers in any other legal occupation. But despite the fact that our clients weren't able to make that argument for the Supreme Court, they certainly understood it nonetheless. us. So that was a good thing. Final provision, which was at issue in Bedford, is of course the communication provision, which, if you will recall, was the provision that was upheld in a split decision before the Court of Appeal. This was the provision that prohibits communicating for the purposes of sex work in public, the most applied criminal provision, and the one that impacts sex workers who work on the street. It means, of course, that sex workers who work on the street must do so in circumstances that expose them to the risk of violence. They have to work in dark, remote places, so they do not capture police attention. They cannot work in concert with other sex workers, and they must conduct their communications quickly so as not to attract police attention. There's a real impediment to screening for intoxication and other potential risk factors, obtaining key personal information from clients, and telling other sex workers where they are working. The Supreme Court, again, had no problem understanding that this provision created a displacement of sex workers to unsafe locations and also prevented them from doing appropriate screening, found in general that it was grossly disproportionate to its legislative objective. They also spoke directly to the Court of Appeal's finding on the communication provision. So 3 of our judges in the Court of Appeal, there had been a 5-member panel, had said, you know, we're not really convinced that this communication plays a great role in sex workers' exercise of their liberty and their safety. And the reason is because sex workers are too fucked up, basically, to screen. And they did their laundry list of how it is that they believe sex workers to be too fucked up. You know, addiction, drug usage, poverty. And the Supreme Court had no traction for that argument, and said that may be true for one person, but more importantly, on the reverse side of that, if the screening, the Supreme Court said, could have prevented one sex worker from jumping into Robert Picton's car, the severity of the harmful effects of that law is established. So in terms of other highlights from the decision, there had been a really strong sentiment expressed by the government over time that you can't link the violence that sex workers experience to the actual criminal code provisions. Rather, the connection that these laws create is not direct. The connection is negated by sex workers choosing to engage in what the government characterized as risky commercial activity, or the violence is created by third parties, which the government insisted were Johns, which of course sex workers will tell you those are not their Johns, those are predators. And the Supreme Court said, no, we don't buy that at all. And they said, certainly some sex workers choose, but some sex workers enter the profession by less meaningful choice, which I think is as close as we're going to get to the Supreme Court acknowledging the feminization of poverty, at least in that decision. They also commented that sex work is not illegal. So they offered a really, I thought, cute analogy in that they said, the causal connection is whether the impugned laws make this lawful activity more dangerous. An analogy could be drawn to a law preventing a cyclist from wearing a helmet. That the cyclist chooses to ride her bike does not diminish the causal role of the law in making that activity riskier. So on remedy, on this victory, this success, there was a declaration of invalidity for those that has actually been suspended for a year. So there's existing confusion. You might have even noticed I use sort of interchangeably past and present tense. It's been left to sort of the discretion of the crowns in various jurisdictions to decide whether they're going to continue enforcing these laws or not in the year in which our federal government has to come up with an alternative. The alternative was characterized by the Supreme Court as that of how to regulate sex work. It was very clear towards the end of the judgment. We are not talking about a criminal activity, we're talking about regulating a lawful occupation. I'm going to offer a few other comments about successes from Bedford, and I would like to say that apart from this immense change in the law that Terri-Jean has directed. We also have had a really amazing growth of community. Sex workers put themselves at the center of crafting advocacy strategies. Sex workers, told their counsel and told counsel for other groups what language to use, and we're very mindful of what strategies could be advanced before the Supreme Court that left no one behind. There was also a growth of allyship, as you saw, a series of supportive interveners appear before the Supreme Court. Aboriginal Legal Services, the Pivot Suave Pace Coalition out of Vancouver, Women's Studies Department out of Vancouver, some out of Montreal, Simone de Beauvoir Institute, the BC Civil Liberties Association, and your coalition of the HIV/AIDS Legal Network, the BC Centre for Excellence in HIV/AIDS, and HALCO here of Toronto. You also had a fair bit of discourse around what was a feminist position to take in Bedford, and there were a series of groups that had appeared before the Ontario Court of Appeal and identified themselves as advocating for an asymmetrical solution and characterizing themselves as a feminist coalition. And leading up to the Supreme Court, you had other women's organizations, again coming out of the violence against women community, saying, we support decriminalization and we are also feminists. So you had a real enriching of discourse around that and of community building. So what's next? What's next for sex work in Canada? That's why you're here. That's what you're curious about. The immediate priority, what I hear from my clients, is to prevent the Nordic/Swedish model, which our Conservative government is shopping around, because it won't protect sex workers nor reduce stigma and violence against them. I'm just going to offer a little bit of the legal reasoning behind the Swedish model, and I would like to say that, an ongoing joke I have with my friends is that I am Swedish, which means that this is the one Swedish thing I don't like. Talk to me about ABBA afterwards, it's forever. Okay, so the Swedish model, which is very much, you will hear about it a lot. It's very palatable for our Conservative government who would like to repackage themselves as human rights defenders increasingly. The 1998 Women's Peace Law in Sweden is intended to eradicate sex work entirely, and the aim is that of gender equality. In Sweden, the legislators passed this law believing that all sex work is a form of male violence against women, which of course erases the lived realities of a great number of trans sex workers and men who have sex with men, but despite that, we stick to that binary when we talk about this model. Criminalizes those who purchase sex. Anyone who obtains or attempts to obtain what is characterized as a casual sexual relation in exchange for payment under the law. There are also related laws. So again, it's not the sex worker that is criminalized, it is the client. There are related laws that criminalize those who, quote unquote, improperly financially exploit sex work, and also who promote sex work by permitting individuals to use premises for sex work and working with others. So the impact of that, one of those latter provisions, is that sex workers are criminalized if they work indoors, or their relations are criminalized for working indoors, and the only safe way to work indoors is to work in your own home. There's a lot of voices from Sweden that are telling us that this model is unacceptable and that it continues violence against sex workers. Sex workers who are indoors continue to be criminalized. Sex workers who work outdoors are criminalized, are made unsafe by the conditions in which they can find and meet clients, and feel themselves further estranged from the community that is meant to be supporting them. Sex workers are unable to work or live with others, including their partners, since it is illegal to share in any income derived from sex work. And the Swedish government has actually acknowledged that they understand that this then makes it harder for sex workers to access and maintain housing, but that's okay as we move towards this new normativity of eradicating sex work. There is no differentiation in Sweden in terms of what is an exploitative relationship, which is again the very concern that Power Mag and Stella raised about the parallel provision here in Canada. And police continue to harass sex workers in order to criminalize their clients. So the real takeaway from this is that although sex workers are technically allowed to sell sex in Sweden, because the law criminalizes the purchaser of those services, the transaction remains illegal. There's an excellent article that was written recently by by Sandra Chu and Rebecca Rose, and I'm happy to pass on that citation if you'd like. They have done a really great job unpacking how they believe that a Nordic model in Canada could still be a breach of charter rights, but they also raise some questions about whether gender equality can be upheld as a legitimate legislative objective at all, given what we've heard from the Supreme Court of Canada, that certain standards of public and sexual morality cannot underlie criminal sanctions. Rather, they must be values that Canadian society as a whole has endorsed. There's an alternative model that is being supported by sex work organizers at the national level, and that is the New Zealand model, which operates from a very different paradigm. There are some basic criminal protections in regards to sexual services from people under the age of 18 or compelling a person to provide commercial sexual services. There are also labor guarantees within that New Zealand regime, and very positive outcomes that the government had committed to looking at after the 10 years of that law being in operation. I'm going to let Chandelle speak to it in more detail, or I can answer some questions about it. So we have these different models that are being debated at the national level, but I think that it's important to recognize that they are being talked about within a climate that still problematizes sex work and problematizes sex workers. First of all, in terms of this new regime, there is no meaningful consultation with sex workers in terms of what sex workers would like to see and what could increase their safety. There's continuing state violence against sex workers. You have a huge conflation of sex work with human trafficking. You have growing policing of poor people. You have a lot of not in my backyardism and a growing sentiment of resistance to harm reduction. There's a phenomenon that has also occurred that was characterized as a national initiative that, again, still problematizes sex work, in which there were cross-country raids of sex workers in their home, in which police officers in Ottawa and in Toronto and other cities called up sex workers and arranged a visit as a John, showed up at the door, rang the doorbell, and said, "I'm a cop, let me inside, and by the way, these 4 guys are also here with me as well." And of course, there's that tension that anyone experiences in an encounter with the police around, if I comply, will I be treated somewhat respectfully? If I don't comply, what are the repercussions? And so what you had were a series of absolutely non-charter compliant searches of people's homes under the guise of looking for signs of human trafficking, and the Ottawa police in Ottawa said, well, we didn't find any human traffickers, but we did find a few girls who were 18 years old and involved in sex work, and 19 years old. So it's very much part of the discourse around, again, conflating human trafficking and sex work. This is particularly problematic that the police is undertaking this initiative, given the confusion that sex workers still feel around what are the current laws and what am I going to be criminalized for, and also the question of what is the damage that a sex worker experiences when a police trespasses into her home and uses basically an abuse of his office to do so. And finally, who's prepared to sue the police? So with that, I will just offer a few last comments about what it is that a lawyer can do and where it is that we need to situate ourselves when we talk about sex work advocacy going into the future. What I hope to convey is that sex work advocacy is not simply about decrim. It's about moving sex work towards a politic in which we view it as labor, in which we view it as a human rights issue, and in which we recognize the sort of various cobwebs that are created around sex workers by criminalization and by stigmatization that, again, continue to divide them and their community. So at the heart of sex work advocacy is putting sex workers' experiences first, wherever the worker is situated. There is no one single narrative of sex work, and there is no one good narrative of sex work. So we need to keep that in mind, and we need to remind ourselves that we don't simply work with the people whose narratives are easiest for us to understand. Sex work advocacy is at the forefront of so many important things in Canada today. It encompasses women, queers, and trans people's experiences of poverty. It encompasses racism, sexism, classism, homophobia, ableism, and whorephobia. It encompasses harm reduction in so many forms and against so much resistance. It involves the agency of young people involved and engaged in sex work. It involves the historical and continuing colonial violence against Indigenous women. It involves systematized violence by police and other state agents and stigmatized labor. So if you can listen to that list and you can start making some of the connections about where the work is to be done, then those are conversations that you can be having with people in the sex work community, and so you should. The future of sex work is not simply about what model the state adopts next. It is about transforming the way sex work is viewed, respecting the radical and brave work that sex workers do in their community, for each other, and for themselves, and reconceptualizing body work as labor. In terms of the lawyer and the advocate, the future of sex work challenges us to do more and to do things differently. Sex work clients are to define what success means for them in the legal realm, particularly given the politicized environment around sex work, the potential cost of identifying oneself as a sex worker, and understanding what safety truly means for all members of the sex working community. Sex workers put themselves in an entirely vulnerable position when they identify themselves in complaints against the police. They also, as a group, put themselves in a politically very precarious place when they advocate and when they are funded by various sources. And finally, there's the question of how do we make sure no one is left behind? Sex work clients are to locate themselves at the center of legal advocacy, especially after a long history of their being objectified and diminished by legal actors. And I rest on the juxtaposition that we have between the communication provision and the prohibition on sex workers being able to communicate about how and what it is that they're going to do with their bodies, and the really firm and growing case law out of the Supreme Court of Canada that talks about consent to sexual activity as being informed, sexually specific, and contemporaneous. And I do not understand how you so that their voices are amplified, not co-opted. It's also about demanding a better discourse from our peers, our colleagues, and our friends. So it's about no more whorephobic conversations, no more anti-sex work rhetoric in law schools. That, in particular, I think we can do a lot better on asking for from our academic environments. And finally, no more pretending that people's lives aren't seriously and irrevocably affected by the criminalization of sex work. Sex workers are our friends, our community members. So I think the role of the lawyer into the future in supporting sex work reform is to say, what is my role in supporting a future that puts sex workers first? In my office, I have a number of posters around because they make me happy. And Power, in particular, has a number of really wonderful graphics around sex work being work and sex worker rights being human rights. And I had a client come in to see me, and that client, Carol, has lived in a rural community in the Ottawa Valley her entire life as a woman of color, who has also been a sex worker her whole adult life. And I hadn't known or understood the extent to which she had connected with supports, but she came into my office to talk to me about something else, probably around the ages of 50 or 55, and she looked up at the wall and she said, "Oh, sex work is work." And she said, "Oh," she said, I don't know if I'd ever thought about it that way. And I think that to me really spoke to the choice that we can make to extend small gestures in our daily lives that indicate to people that they are part of our community and that we are keen to understand and support their experiences. So I leave it to this audience to think to yourselves, what are the large and small ways in which you yourself can support the amazing things that are going to happen in the future with the sex work community in Canada.
Thanks, Karin. Sorry for mispronouncing your name. I want to introduce next Chandelle Gallant. Is a Toronto-based intersectional feminist activist, educator, and writer who works with Maggie's, Toronto Sex Workers Action Project. Chandelle has worked with sex workers in Australia, the US, and Thailand, and has been published in The Revolution Starts at Home, Dear Sister Letters from Survivors of Sexual Assault, The Walrus, and Spread magazine, among others. Inspired by prison abolitionists, she co-founded the blog Everyday Abolition, which collects stories about how people resist prisons and policing in their everyday lives. Please welcome Chandelle.
Hey everyone. Oh, podiums are so weird. Okay, can everyone hear me okay? Well, I'm loud, I don't really need a mic, but I know it's for the cart person. Okay, so I want to start by thanking everyone for having me here today and acknowledging the territories that we're standing on. And I want to offer gratitude and respect to the Indigenous people of this land. And also, I'm grateful for the powerful opening we had and for the opportunity to bring the elders into the room, so thank you for that. I'm also so delighted to be sharing this panel with Karin and Terri-Jean and Audrey. One of the reasons I love doing this work is because I get to hang out with really badass women. We're talking about what's next after the Supreme Court. And as Karin mentioned, it's very likely that the Conservatives are going to introduce a model that is called the Swedish model or the Nordic model. And so a lot of us don't really know much about this model. I had to get educated on it really quickly over the last couple of years too, when it looked like this was something that we might be living with. And the question is, what does the Swedish model look like in real life? And I'm going to talk about that. The answer briefly is pretty much like Canada. It's not that much different than the systems that we had before the Bedford decision. And I'm going to explain that and break it down for you. So the Swedish model punishes clients. One of the main problems in doing that is that it works. It reduces the number of clients. But the state doesn't step in to actually replace any of the lost income for those sex workers. And so there's the same number of sex workers because they still need jobs, but there's fewer clients. And so the privileged people who created this garbage law, the Swedish model, don't seem to actually understand things like jobs and that people need them, no matter how much you might hate their job. So conservatives, fundamentalists, and prohibitionist feminists are all like, let's get rid of the evil of exploitation against women. Again, as Karin mentioned, not recognizing at all the diversity of genders actually in the sex trade. And sex workers of all genders are like, well, hi, but you're not paying my rent, and so I still need a job. So when the Conservatives introduce the Swedish model, like as they likely will this year, it's not going to come with plans for affordable housing, or daycare, or increases in welfare or disability rates, is it? I haven't heard that. So of course people are going to stay in their jobs, only now their jobs are going to be harder and more dangerous. In fact, their whole lives are going to be more dangerous. So it strikes me as incredibly disrespectful of working people to steal their jobs instead of supporting them in improving their workplaces. Every worker deserves rights, respect, and self-determination, especially those who might be facing exploitation and violence in sex work or any work. Workers who are undocumented, youth in the sex industry, all of us. I don't believe in leaving anyone behind. So I'm going to talk about how the Swedish model reshapes the working lives of sex workers and how it also impacts their intimate lives. So Swedish researchers themselves, the National Police Board and National Council on Crime Prevention, found that after the law was introduced, there was no reduction in prostitution since the ban on purchasing sex. What has happened is that it has become more hidden. That's how they described it. So how is it being hidden? Who's being hidden? What happens to people who are hidden? Well, how it works is similar to Canada. Areas where sex work is happening on the street are subjected to police surveillance and harassment, and this scares away clients. Like I said, people need their jobs, so sex workers just have to move to more and more isolated, dangerous areas to find those clients. Being pushed into more isolated areas means they're pushed out of neighborhoods they're familiar with. They're no longer able to work with the people they're used to working with who might warn them about aggressors posing as clients in the area. Workers make less money, and so they have to stand longer on the street, hustling harder for fewer clients, taking clients they might have turned down before. Katrina Pacey of Pivot once said to me, if people don't like street work, they sure aren't going to like the Swedish model. because the Swedish model actually increases the amount of time someone needs to spend on the street. Clients are scared of law enforcement and are in a rush, and so workers have to make those snap decisions about whether to go with them, preventing them from taking the basic safety precautions, like checking to see if his appearance matches someone described on a bad date list, detecting whether he's under the influence of alcohol or drugs, very importantly, assessing if there was anyone else in the vehicle with him, and checking in with the worker's own intuition about the client. Instead, what it looks like is jumping into a car quickly in a poorly lit, isolated area without other sex workers around, going with clients they might have turned down in the past, offering services they might not have offered in the past, but now they need to because money is so much tighter because there's fewer clients. This all adds up to an increased vulnerability to violence on the job. And this should sound familiar because this is similar to what we have had here. And police have used this style of enforcement here in Canada. In 2001, Montreal police used this method to undertake raids on clients. The Montreal sex workers organization Stella tracks incidents of violence against sex workers, and they saw that in the months following those raids, the violence against street-based workers skyrocketed. There was a 300% increase in assault and a 500% increase in assault with a deadly weapon. So when I asked them why this happened, they reported the same reasons that I outlined above. Snap decisions. It was overwhelmingly against street-based workers who were made vulnerable for all those reasons I just outlined. And this research repeats itself and repeats itself everywhere in the world. It's not rocket surgery. It's very well established. So who is this impacting? Well, any change isn't going to impact sex workers equally. We don't live in an equal world, and the laws don't impact you equally, and you all know that if you're here. So far and away, the majority of the violence is directed at sex workers who are street-based, even though the majority of sex work is indoors. In Sweden, they did see a 50% drop in street work, which they claimed as a victory. But this happened at the same time everywhere in the world because of the introduction of cell phones and the internet, and a large bulk of sex work moved indoors. And people are still on the street in Sweden. Because in order to be an indoor worker, you need to have an indoor. You need to have a home, right? And not everyone has that. So while street work has dropped, the number of migrants in street work grew until they're now 50% of street workers. So again, we see this familiar pattern where racialized and migrant people are being over-policed and pushed into the least protected parts of work where they have the least supports. For indoor workers, it's also a problem. Clients want to be more hidden, right? They're trying to avoid law enforcement, they're subjected to surveillance and stings, and so what they do is they increasingly refuse to give screening information like phone numbers and emails to sex workers who are trying to screen bad dates out. They start to prefer what are called out calls instead of in calls, where the sex worker goes to their location instead of staying in their own. And for those of you who don't know, that is more dangerous for the sex worker because someone else's location is not under your control. Regarding public health, if you can believe this, in Sweden, HIV prevention with clients was completely halted because that was seen as supporting prostitution. Possibly one of the dumbest public health moves I can imagine, but this is what happens when you put moralism about sex work above the actual needs of sex workers. So it is still illegal under the Swedish model to hire anyone as support, security, reception, a driver. It remains illegal to work collectively with other sex workers, like in Grandma's house. And for those of you who don't know, Grandma's house was the home of an Indigenous trans sex worker named Jamie Hamilton, who opened up her home for other street-based workers in the downtown east side, in the midst of the Picton slaughter. She was shut down by the police. That kind of Grandma's house is still illegal in Sweden. So if you think that the Swedish model decriminalizes the sex worker while just punishing the buyers, think again. The legal models of Sweden and Canada aren't that different, and that's exactly why the Conservatives like it, because it's business as usual and the sex workers pay the price. I once heard Terri-Jean refer to the Canadian laws about sex work as the Picton model, a very grim description of what we have, the perfect storm that allowed predators to prey on sex workers for decades and get away with it. The Swedish model is the Picton model by another name. So I've shared the bad news about how the Swedish model damages sex workers' safety and freedom at work, but it also has a larger impact on the private life of a sex worker, and it leads to increases in partner violence. In July of last year, a woman named Petite Jasmine, a sex worker from Sweden, was murdered by her ex-husband. He had been abusive, he'd stalked and threatened her, but despite this, he had been given custody of their children because Jasmine was a sex worker. He'd called her in about it, and he'd reported her, and she was deemed unfit as a result. The courts told her she did not understand that she was self-harming by being a sex worker, and that she lacked insight and was romanticizing sex work, so they took her children away. They did not offer any protection from her abusive ex. How did the Swedish sex work laws contribute to Jasmine's death? 1. This model still makes it illegal to house a sex worker, just like in the Picton model. So that means sex workers in abusive situations are more likely to be stuck and unable to get new housing if they want to leave their partner. And people in the anti-VAW sector acknowledge that access to housing is key for stopping domestic violence, especially for mothers. 2, because sex work is defined from the start as violence against women, social service agencies will remove sex workers' kids, as they did with Jasmine, if they find out. The abusive partner knows this and threatens to reveal it to social service agencies if she tries to leave. This is what happened to Jasmine. Her kids were removed within hours of her ex reporting her. 3, sex workers have an antagonistic relationship with the police, so they can't call for help when their partner is abusing them. Again, many people can never call the police for help because of the systemic oppressiveness of police. But for those who would even consider it, they have to consider, what if my partner discloses my sex working status? 4, sex workers are actually refused domestic violence supports on condition that they leave sex work. So they can't even access supports they need to get out of an abusive relationship and stay alive. And this can have fatal impacts. 5, remember the problem of the fewer clients that I mentioned, and how people actually just keep working. You can politicize your clients about the criminal legal system. And I think of this as allyship 201, where you get other folks to see some of the links between their own experiences, even though you don't necessarily share them. If you're a teaching lawyer, how can you ensure that everyone under you also respects clients and model that? It's so powerful. The Supreme Court victory I think the victory may not end up being legal, because if we get the Swedish model like I've outlined, I don't think it may not substantially change things. We had the example here in Montreal where it might actually increase violence against street-based workers. What it is, though, is a psychological and spiritual win. Things might get worse for sex workers as the industry deals with new legislation, and people will keep working through that. But what has changed is that sex workers now feel this buoyant sense of possibility, like never before. So many workers are speaking up where they can now about their experiences. And sex workers and our allies are on the right side of history, and no matter what happens, there is no going back. People feel a sense of pride, they feel a sense of possibility now because of this decision. Sex workers around the world are creative, smart, funny, loving, strong, and highly capable. We are organizing everywhere in the world, and every day we take care of our communities to reduce HIV and violence. There's nothing intrinsically violent about sex work, but what our society has made so. Sometimes we forget this, but the reality is we do actually have all the tools we need to solve our problems. I want to thank you for taking the time to listen to me and to offer respect to my sex working ancestors who fought so hard and so long so that I could stand before you here today. It's on their shoulders that I stand, and I hope that I've been of service. I see my work as accountable to sex workers, and your feedback is warmly welcomed. Thank you.
Thank you so much to all three of our panelists for those very informative and, for me, very stimulating words. We have about 20 minutes, so if you have questions or comments, I would invite you to either come, if you can, to the front here, because then we will also be recorded, if you're okay with that. We are going to be putting this up on our union website, or we can also bring a mic to you. So whichever you prefer, please just raise your hand if you'd like to ask a question or make a comment.
Ask for inclusion in the Occupational Health and Safety Act, and if it's denied, then to take it to the Ontario Human Rights Commission. And I guess I'm thinking to not just look federally, but what we can do provincially and municipally for this issue.
Sure. I think that's a great question. I think that right now there's sort of a prioritization of resources around what could potentially be passed in terms of criminal laws. But also there's a really healthy group forming that I think is interested in different types of lobbying and reform. So I think we'd be happy to take people's information and bring people into the conversation.
Yeah, I think that's also a really lovely idea. I think right now all the resources are going into attempting to lobby against the introduction of new legislation. And I think the new, whatever comes out in the new legislation will really shape where the work goes from there and whether or not we're in a position to start advocating around labor protections.
Government consultation. I know that there was an online consultation that closed on March 17th, on Monday, and I'm not sure if any of you know. So I don't think there's been a report released on that yet.
I think it's likely there will not be.
Do you want to say a little bit more about that?
I think that the Conservatives have been very careful around using very vague language about who they're speaking to. They have had one in-person consultation that involved members of the sex work community, but they have not identified that as such, and they certainly, I think, are loath to acknowledge that they are hearing from sex workers and sex worker allies.
Any other questions or comments? Okay, great.
Just want to say thank you so much for sharing your work and your thoughts on this. As public figures and like advocacy for sex workers, what is the way to get them to hear you out? Like, it's really scary that they would pass a law without even consulting sex workers, even though it is about sex workers, and it's got to be frustrating. Like, so I don't know how you would work around that.
Terri-Jean just said sympathetic media, and you know, what I think is community building. I mean, the thing is, we have to organize regardless of what the state is going to do to us. The state's not our friend. It's not we're in an antagonistic relationship. So sex working community has always, and actually every marginalized community in these lands has found a way to work around and resist whatever fresh tragedy the state tries to impose. But I see the solution really in the solutions in sort of more local and community-based work.
And we have, oh, that's loud. I have a really brief comment and then a question. So my comment is just that it's just the smallest comment, but I just wanted to make sure that it got out there in the room that I think it's really important to interrogate lawyer-client relationships, but it's also important just to make sure that we don't erase all the amazing sex-working lawyers who are out there. So, and not to think that because someone is a lawyer acting as one doesn't mean that they're not also a sex worker or haven't been a sex worker. Most of the amazing sex workers I know I met in law school. So, and my question was just that I know that I think Karin, you spoke to this briefly, that the several attorneys general have made statements or sort of enacted policies about what they're going to do with charges in this strange year-long interlude that we're in. And I was wondering if you could maybe just provide a little bit more detail about where things are at.
So yeah, your question was around what we know about the laws and their operation right now?
No, sorry, what's happening, like, my understanding was that I think New Brunswick had come out and said that they're not going to be pursuing charges? Like, what's going to be happening? What are the approaches that attorneys general or municipal police associations have said that they're going to be taking across the country? I'm just curious, because I know that some people have made some statements, but I don't know much about which provinces, which cities, that kind of thing.
Oh, yeah, I don't know off the top of my head which ones have, but some provinces have come out and stated that they are stopping enforcement. I think Newfoundland and BC are two that I can think of off the top of my head right now.
Yeah, and I think that also is sort of a problem, is that it's unclear who gets to make decisions around that. In Ottawa, we have a police force that's, very devoted to continuing to enforce the laws, whereas in New Brunswick, the conversation was at the Attorney General level, so it was the Crown, because we're gonna cease enforcing these laws. So it's sort of, there's a real lack of transparency around how those decisions are even being made and by whom.
And I think the other governments are going to wait and see what the Conservatives do before they start reacting. And that'll also change the landscape next year.
Did everyone catch that?
I think it's important to remember that we have an election year coming up, and the other governments are just standing back, waiting to see how the Conservatives react, and then we'll hear more of an overview of how the country feels. But I think this is going to keep playing out for a couple of years before they really settle on a decision on a law. But I know they have to come up with something in December. They're just shuffling their feet. I think they're in Ukraine right now.
And there was good news today around the Supreme Court appointment, so they'll be busier still. So.
And we have a question over here. Would you like to come to the front? That'd be great.
Yes, okay. Thank you so much for the presentation and your hard work. Really new to learning about the issue, and I was really happy to hear everyone's perspective and sort of gaining the knowledge and what we can as lawyers help the marginalized communities and sex workers. I had a question about best police practices, because you talked about the New Zealand model, but what about police and because we kind of think about it in terms of police and state as an opposition, and are there any best practices of helplines or police forces dedicated to helping sex workers that are harassed or assaulted? Are there any examples that we can look up to? That was what I was curious about, and thank you again for all your work.
Most of the police in Ontario are hands off. They're not doing anything right now. And they don't want to do anything. They're on our side. I think that's the question you're asking.
Well, I'm wondering in terms of I wasn't just thinking about Ontario specifically, but in terms of Canada and different municipalities and the different police forces. When we look at the police and their engagement with sex workers, how helpful are they when sex workers are assaulted? Are there any helplines? Is there any dedicated police forces specifically to address sex workers' assault? And are there any practices around the world that we can look up to?
I see what you mean.
So,
advocacy inside the police department.
yeah, you know what though? So there's a special victims unit in Toronto, which is a small office. I think they have 2 officers or something like that. That's supposed to address complaints by sex workers. But this is what's turned me into a prison abolitionist. So sounds like a fine idea, right? They're supposed to be police officers who have a higher level of understanding and respect for sex workers, understand the issues. But this is how it actually works. Unfortunately, a couple of things I'm going to name. One, I don't know if it was 2 or 3 years ago, The police, first of all, the police regularly conduct raids still. So the Special Victims Unit will disguise themselves as clients. And then multiple armed officers will show up at a worker's location and start demanding identification, do illegal searches, all the same stuff. And when I talked to a police officer about why they did this, he said, oh, well, you know, some of the girls, they don't want to talk to us at all. But, you know, we just need to make sure that they understand what assault is. We're there to, like, teach them what assault is. How do you even keep a straight face when this random dude is telling me that his job is to help a sex worker understand what assault is? Because I guess we're too stupid to figure that out ourselves. So they do that kind of stuff. They do engage with sex workers in ways that I think are harassing and undermine sex worker safety. They went even further in that one of the times they did this, they had a hotel room booked. They called sex workers in to come work, and they invited the Toronto Sun to film it. I have never heard about sex workers who have the police to be a source of genuine protection, unfortunately.
She also wants to know about municipally.
Well, I am talking about municipal
Yeah,
police.
that's pretty encompassing. Just
Yeah.
encompassing.
Yeah. And then as for best practices, I mean, within a Canadian context, the best practice I know of is really just non-enforcement of the anti-sex work laws, and following up where there is a complaint. But when there's a special office dedicated to sex workers, at least in the Toronto case, it's not working.
Thank you. Do we have any more questions or comments? We have one in the back. There's a microphone on its way.
Hi. Oh, that is really loud. Thank you. Also, to reiterate others, thank you. I heard today about what some police are doing in the Maritimes. In Nova Scotia in particular, they're taking phone numbers from escort ads in the local newspapers and they're texting them the signs of assault. And they're telling them to seek help and come forward and all these things. I was wondering, have you heard of that trend sort of spreading in this direction? Because I know there's been the back page raids, there's been the human trafficking raids in Ottawa and Toronto. Has this similar phone solicitation sort of thing been happening here as well?
No, I haven't heard of it, but it's not that different than what the police are doing with the raids, where, you know, that information, like the information's name, phone number, and location of work is being recorded. And sex workers are not happy about that. Again, it doesn't really feel like a source of support. You know, an analogy I'm going to make is, we know that there are high rates of domestic violence. If you wanted to support someone who, let's just talk about domestic violence here in Canada. If we were concerned about it, would the solution be to pose as, say, a repairman, make an appointment with someone, arrive at the house with actually 4 officers, demand to be let in, and then interrogate the person about whether they're experiencing domestic violence? Do you think that would be a useful anti-violence strategy? So the issue isn't that there's no violence or coercion or exploitation happening in sex work. There is. The issue is that the solutions we're being offered make it worse. And what you've just described is texting people, sex workers, to tell them what an assault is. That is so deeply patronizing, I just can't even.
Imagine going after regular women who have sex for free with the same enthusiasm.
We need a microphone.
I'm wondering what the experience has been of any of you or each of you in alliances or discussions with groups representing consumers of the services that sex workers provide. And here I'm thinking in particular of the disabled community, but perhaps other that you may have had some contact with and built, in fact, alliances with.
Lots of clients with disabilities that use the services of a sex trade worker because they find her services are quite therapeutic, very valuable to their well-being. And vets. Lots and lots of vets.
Have there been any alliances with, do they organize at all, or?
There's no client organizing in Canada. There's one guy, Chester Brown, who's a graphic novelist who wrote a book called, I think it was called Paying for It.
Yes.
Yeah, Paying for It. That's pretty much it. Clients are more organized in Australia, where there's an organization called Touching Base that connects the disabled community with sex workers. But there's nothing like that here. And of course, that actually happens in New South Wales, Australia, which has decriminalization, and that's why.
Any other questions, comments?
We've got one over here.
I am Susan. So I'm thinking of two competing streams here. So I think talking about education and post-Bedford, and so I just want to applaud the panel. Missed part of it, trying to find the place, but caught part of it. So, but I think it's really important that these kind of forums become more common and widely publicized so that people who don't know a lot about sex work can learn more about the human aspects, and it's around organizing too. So I think that's really important around educating people who don't know a lot about this, who may believe what they've heard the state say about sex work. Which brings me to the state and the comment about the state's role in criminalizing human beings as part of its capitalist project of agenda of imprisonment and police harassment. And the decision was commented. So this government, this law and order so-called Harper government is 3 for 3. I mean, they've gone around the law each time. They've appealed this case, Bedford, up to the Supreme Court and lost, and so they're looking a way around this. They lost on the supervised injection site, quite clearly on that one too, and today they lost it. They didn't even follow the Constitution in appointing judges to the Supreme Court, so they're not the best, and you know, if they look at their record in the Senate and a whole bunch of other places. So I want to talk about political organizing too, so the education piece, but we really need a government that respects human beings and a state that does not see its mission in life to criminalize and imprison people. So just want to put a couple of those pieces out there, and getting people politically active as well as community active. And so just some thoughts. I see the kind of nodding, and so just wanted to put that out there for people to consider, and remember to vote on election day. For somebody that likes people.
Thanks so much, Susan. And by the way, Susan is going to be moderating our keynote address and panel on trans legal rights tomorrow afternoon. And I hope that we get better at advertising where this place is. We almost do Chanel or our elder arrive either. I think we have time for 1 or 2 more comments, questions at the most. We have 2. Great.
Just to add to the earlier discussion about different provinces, I believe that Alberta has actually basically instructed its Crown attorneys to implement a version of the Swedish model.
It's illegal if they're doing so.
What's that?
It's illegal if they're doing so.
Well, definitely, but they've issued some kind of, I read it weeks ago, some kind of instruction where they're offering their own interpretation of the Supreme Court's decision that says, so this means that we're not going to arrest sex workers, but we'll go after the clients who are exploiting them. So that's Alberta. I'll just thank the panel again for being very inspirational, very interesting. I'm an academic lawyer and teach in the area, and it's certainly given me a lot of food for thought about how to go on teaching about sex work. I wonder if I could ask a kind of academic question. I don't know if I'm opening up a can of worms that no one's interested in, or because I teach in New Brunswick, maybe everyone's talked about this in Toronto and already settled the issue. But the thing that's really struck me as, you know, a feminist who's been around for decades in various parts of the women's movement is Janice Raymond is an expert witness.
What?
And yeah, exactly, because when I read the Justice Hennell's judgment, I couldn't believe it. Janice Raymond, it's like hit in my head, because Janice Raymond wrote, I can't remember the name of the book, the
Transsexual Empire.
Yeah. So partly I have this sort of mission because I want everyone to know that. And I'm just wondering if anyone in the panel has any comment, because the, you know, as an academic, I read what the prohibitionists or feminists are putting out, and they're really promoting Janice Raymond a lot. And they seem to be becoming more and more explicitly anti-trans as well all the time. So I'd love to hear if anyone else has been thinking about this at all.
So for folks who don't know, Janice Raymond is evil. Let's start with that. Thank you. Yeah, let's get that on the record. In the late 70s, in the late 70s, she wrote a hate screed called The Transsexual Empire. And the book, I couldn't even describe the devastating impact that that book has had on trans women's lives in particular. And she has also advocated for eliminating medical services to trans people, sometimes successfully. And there is this bizarre, unholy alliance between people who are anti-trans, specifically trans-misogynist, and people who are anti-sex work. And so Janice Raymond and many of her ilk have moved from being professionally anti-trans to professionally anti-sex work. And she is one of them, and has been employed by the UN, and really should have no place. Like, it is completely inappropriate for her to have a public role around sex work, and for her opinions to still be considered valid. So I can't speak to that except for some of the deep problems in feminism. Feminism really, as a feminist myself, feminism struggles real hard on sex work and internalized trans-misogyny. Mystery to me about the close relationship. If anything, though, I will say that it has built relationships and solidarity between cisgendered sex workers and trans women communities, and that's a beautiful thing.
Okay. We have one more comment. Is that still the case? There we go.
Thanks again. It was really interesting. I was just wondering if maybe you could close off by commenting on at least the small part of Bedford that I perceive to be less of a victory, which is the decision on leave to intervene. And I thought it was appalling the number of sex workers organizations that were shut out and not given the opportunity to be heard. So as we move forward post-Bedford and to try to build a system that does work and is affirming for those involved in this work, how do we make sure that doesn't happen? And also, just was it perceived within the relevant communities to be the slight that I thought it was?
Yes, it was. And, it's the problem with intervener applications before the Supreme Court is you don't get any reasons. So it's forever a question in our clients' minds as to why they were not able to be heard, although there certainly was correspondence that was provided to the court by attorney generals suggesting that there was no value in some of the intervener applications, Power Maggie Stella being one of them. But I think what was of some reassurance to Power Maggie's and Stella is that there was still a tremendous amount of cooperation that existed amongst various groups in crafting arguments that really could be endorsed by the larger community. So there was a lot of work that was done outside of the intervener applications that still ensured that people's perspectives were understood and shared.
Okay, I think we're about done unless there's anything else. I just want to thank all three of you, Chandelle, Karin, and Terri-Jean, so much, not just for today, but for all the work that you do. I'm truly inspired and honored to have been on the panel with you, or moderating this panel with you. And I'm really grateful to all of you for coming out, and to the Law Union. Again, I hope that more people will come out tomorrow. We start early at 9 a.m. One of the panelists, Karin, I think, mentioned Naomi Sayers in her talk. She's going to be, or you mentioned her, yeah. She's going to be speaking tomorrow at 3:30 on missing and murdered Indigenous women. So and for people who weren't here, we'll be posting that we have videotaped this, and you can let your friends know if they missed it, that this will go on the Law Union's website and other places too, I believe. So thanks again, everybody, for coming out. And